Welcome to Inside Employment, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in Australian employment law and practice.
Well, hello and welcome to Inside Employment, a podcast series by Herbert Smith Freehills Kramer that looks at key employment issues and developments facing employers in Australia. And I'm delighted. My name is Tony Wood. I'm a partner in the employment practice here in Melbourne. And I'm joined today by my great friend and colleague, Lucy Boyd, who is an executive counsel with our firm. And we have a very special guest today with us, one of my colleagues in our corporate team, Priscilla Bryans. Welcome, Priscilla.
Thank you.
And welcome, Lucy. How are you?
I'm great, Tony, and delighted to have you here, Priscilla. And you're the perfect person for today's episode because we'll be discussing key issues for senior execs and boards.
Which is really opportune. And I must say, how are you feeling, Priscilla? Because you're dealing with all of those monster kind of corporate titans every day, not to mention our corporate partners that you need to manage in your role as managing partner in Melbourne. So are you coping okay with them?
I'm feeling good.
How do you deal with all of those egos?
Oh, the egos are fine because I usually deal with the chairman and the company secretaries and the general counsel who are doing all of the sort of smoothing over in the background.
So I thought, well, thank you for joining us, Priscilla. And I thought, Lucy, you've got some data, and it might be a really good way to start off this session because maybe just before we do, a lot of the work we do as employment lawyers has this incredibly deep and rich vein which explores into the work, Priscilla, that you do, which is really in our corporate team in dealing with executive incentive issues, termination issues, succession issues with C-suite employees. And of course, as you mentioned, you're dealing a lot with chairs of those businesses. So we become involved in a lot of those. And when we read about it in the Financial Review or the press, I always scratch my head and think, that's not what really happens. So I want to try and use a little bit today to explore what is the truth behind what happens with some of these arrangements. So maybe, Lucy, you had some really interesting data that talked about this too.
There was a very interesting article over the weekend in the AFR, which had a catchy title of CEO Killing Season, and had some interesting stats. So since the 1st of January of this year, 15 of the ASX 300 chief executives have departed or announced their departure. And there was also a reference in a Wall Street Journal analysis which says that 1 in 9 CEOs of the top 1,500 public companies were exited last year. So that's 9%, if my maths is correct, and that's a huge figure, it seems to me. And I'm interested, Priscilla, do you agree that there's an upward trend or a rising number of these exits happening at this point in time?
I think that's right. Australia's followed the US lead. We had a big turnover at the end of 2022. So it was almost as if people got through COVID, waited 12 months just to see what the lay of the land was, and then decided they needed a new CEO with a new set of skills. Typically companies choose CEOs for a particular task. So it might be a growth strategy, it might be a cost cutting and resetting strategy. And just recently we have seen a big uptick in CEO and CFO changes. What's caused that? It's a little harder to tell, but I think that the lack of certainty in the US and the trade situation there, but also cost cutting and resetting agendas in relation to things like climate transition. I think there's a new direction, and people are suddenly realising that their current CEO is perhaps not fit for the task and they're looking for a new one.
But I mean, this doesn't happen by accident, does it? I mean, well, I suppose if it does, there's generally a story if you scratch the surface, right? Because having worked with you and others in your team for many years, you just know that a CEO, or actually even any of the C-suite successions, take a lot of planning.
Yes.
So just tell us a little bit about that and what kind of timeframes are we generally looking about?
In my experience, it's two extremes. You either have a beloved CEO and they can take up to 18 months to plan their departure. There's a lot of thinking through when they'll give notice, and point about that is that for a CEO or a CFO or anyone on the board, when they resign, there's an immediate obligation to notify the stock exchange. So discussions around intentions to resign but not resigning, they can happen up to 18 months in advance, and there'll be a lot of thinking through who the next candidate will be, how to conduct a search externally and internally whilst maintaining confidentiality so that it doesn't leak, thinking through the termination benefits and the arrangements for the outgoing executive, thinking through the package for the new executive, training for the new executive if they're coming from overseas and they're not used to the Australian system. So it can take 18 months. The alternative is I have come back from lunch one day to be told that there was a chairman downstairs who wanted to see me. And I literally walked into the room not knowing who it was, and we had to sack the CEO on Monday and it was Friday. And my job was to look through the annual reports, gather as much information as I could, and put together a letter, and it was done on Monday.
So, wow, there's so much to unpack there. I mean, by the way, when that happens, and we get those calls as well, there's normally an incident, there's a spike, there's an allegation, there's an investigation, there's something or there's a hissy fit, or something's happened to cause the board to either lose confidence, or alternatively for the CEO to threaten to depart the business. So I'll put that aside for a minute and just talk about the planned succession. And of course, the important element that you spoke about was the disclosure obligations to the Australian Stock Exchange, the ASX. Now, of course, we're talking about publicly listed companies, of course, when you do that. And certainly a lot of our work, and yours as well a little bit, is with private companies, and there's a profusion of kind of private equity businesses that run, and probably run much more nimbly, actually, don't they? Because they're not constrained by those same complex notification requirements in the Act. They're still governed, of course, by the Corporations Act, but not the additional layer of governance, right?
Yes and no. I think the biggest difference probably is actually the activist shareholders agitating in the background to move people on. The disclosure obligations are tricky, and you have to be careful about your timing. But actually, it's often the large, loud shareholder who's also talked to other cornerstone stakeholders that then trigger a change of CEO.
Yeah, we've certainly noticed that with a few CEO, we've been involved in misconduct, and perhaps the board has taken action for, in relation to incentives or demotion or something like that. And then you see the activist shareholders, often those big super funds, jump in and say that's not acceptable, that's not aligned with our values, and then they've sort of had to change course. Which
leads to issues at AGMs, and then first and second strikes on your remuneration reports and all of those kind of problems as well. So I just want to go to the other element though that you spoke on, that sudden meeting that you have with the chair, and so we want to exit the CEO. We've got a problem with one of the senior executive members. And we see that a lot, and often we'll bring you involved as well, or vice versa, the way that it turns out. But are you, I'll put my proposition, then ask you if you've seen the same thing. Lucy and I are seeing a much greater willingness from boards to not tolerate, or a much less tolerant atmosphere in terms of behavioural problems within a business. And anecdotally, and I think this is true, I have a view that the much higher proportion of female non-executive directors has also, and chairs of larger businesses, has had an impact on kind of the values of the business being prioritised, when I think more in the past there was a very quiet aside by the the fuddy-duddy old male chairman to the CEO who may have been misconducting themselves. Anyway, there's a few things you can unpack from what I've said there. But are you seeing that? Are you seeing a much lesser tolerance of aberrant behaviour?
Yes. I'm seeing There are a few things in there. It's a great topic. I think that whistleblowing and the ability to remain anonymous in the whistleblowing process has changed that a little bit, because that then turns into investigations, and when it involves the CEO, usually they'll bring in an external investigator because you have to handle it appropriately. And I agree. We've worked together on lots of those. The other thing that I'm seeing more of is holding people to account with remuneration. And that's not even to do with, if it's misconduct, typically misconduct's the highest level. Slightly iffy behaviour, even that often will get someone sent on. But just poor performance, overruns, cost overruns, we're seeing a lot more holding people to account and remuneration being docked in incentives.
And so when we get to that pointy end of a separation, so we take instructions from the chair, and the chair says, okay, we've made this decision, we're going to exit the CEO, for instance, and we want to, almost inevitably they'll say, we want to prepare a separation agreement or a deed. It's not mandatory, of course, to do that, but I think all parties would generally like the certainty that comes with a separation agreement.
Yes.
We know you're leaving the business. These are the terms. This is how we'll treat the incentives. This is when the date will be. This is when the garden leave will occur. This is where you won't make disparaging comments, and we'll mutually agree to that, and we'll mutually agree to release each other from any claim. So all of that will be wrapped up in a nice, neat agreement. That takes weeks to negotiate.
It does. And it takes a lot more review of documents than anyone ever expects, because the way the termination benefits provisions work, incentives can be termination benefits or not termination benefits, depending on whether or not the board is required to make a decision or exercise a discretion in connection with the executive ceasing to hold their position. So if the documents are drafted well, then the executive will be a good leaver in all scenarios except resignation or summary dismissal, and then the board can exercise its discretion to take those benefits away. And ideally, the remuneration will run on and vest based on performance, not accelerate or vest on cessation of employment. But you'd be stunned how many people get that wrong. And that's something you have to set up at the start of the grant, not at the end of the grant. And any attempts to change it when they're leaving converts it immediately into a termination benefit. That's very tricky, working out what they've got, what they're entitled to, and then putting that in the separation deed.
Yeah, and there's no such thing as a standard or default plan rules for an STI or for an LTI, but you've explained what is more common and more likely. But getting that right is so important.
And then it means that after they've separated, you can still look at their behaviour, and if things come to light, as we had one where it was a mutual separation, and then afterwards, when the CEO leaves the building, you discover with horror what's been occurring, the board still has the discretion to take it away.
So if you have a separation so you might be on good terms, you might have a separation of a senior executive, and the terms of the LTI and STI will be as they fall under the terms of the plan rules, and the payments can be made, or allocations of shares can vest. But even under those plan rules, there's still the opportunity for clawback, for instance, which is very, very, very rarely exercised. But tell us how that works.
So that's a really interesting one. There are two concepts there, malice and clawback. Malice is where before it vests, you decide you'll lapse it. Clawback is you've vested it and then you have to get it back. So clawback of cash is tricky. Clawback of shares is usually possible, because if the executive has not sold their shares, you can literally just execute a transfer and take it off them and put it back into the trust. We are seeing more and more litigation from angry CEOs, former CEOs, who are saying that's not what was agreed, I wasn't a bad leaver, how have you not vested my equity? And traditionally, companies have just said, well, sue us. And the executive would not want to run the gauntlet in the media,
Reputation.
saying I am a good person, even though the company says I'm a terrible person.
I'm a sexual predator. I'm not a sexual predator.
Correct. Let's have a fight about it in court.
That's right.
but
Well, if they want another job, it's not a good way to go about it. And I guess from a legal perspective as well, it's a hard case to win from the executive's position, because you'd have to prove that the clawback or the malice was arbitrary or what's the word?
It was irrational.
Irrational or arbitrary.
Capricious.
It's a very high bar.
Capricious. So that can happen at the end. Of course, it can happen at the beginning of the process as well. So, or at the exit, the immediate exit process.
The company gets 2 bites at the cherry.
They do. And you're quite right, Priscilla, that and I can recall multiple episodes of this where the company exercises makes a decision not to exercise its discretion to grant a certain benefit, or conversely takes it away.
Yes.
And that's challengeable, legally challengeable,
Of
if it's a misapplication of the discretion. But with very few exceptions, that isn't litigated for the very reasons you outlined. It's just too controversial. Who wants their reputation sullied in that way?
Trial by media.
Even where the executive does challenge it, no shareholder is going to be angry with the company for taking a stand. So even if the executive wins and gets their remuneration, I think the company can defend that it tried to do the right thing. So
it's easier to keep them on high ground. And I think the McDonald's case in the US a few years ago, where they drew the line in the sand from the CEO and said, we will not tolerate. I think he did a below the belt selfie in Jeff Bezos style or something, but and it was inappropriate. It was to a fellow employee, and that stuff they just said, no, this is our line, and we won't go past. Convenient for them at the time, but you have to set the standards and values.
I think that's right. In this climate, you can't not do that, or your activist shareholders will come out and make it known. I am interested, Priscilla, just going back to the article we discussed at the start. One of the aspects that was raised was that, we have CEO exits where it may not be their choice, or it's a planned succession, and they also mentioned a trend of CEOs themselves sort of self-selecting out because this operating environment we're in now with regulatory expectations and scrutiny is burning them out. Do you see any truth in that assertion in your practice?
That's a really great question. I think being a CEO is probably the loneliest job in the company, because you're the top of the pile with the executives. So all of your colleagues are going to be very warm to your face and possibly wanting your job behind your back. And on the board, you're an equal amongst the other directors, except that the most important job that the board has is to replace the CEO when it's time. So you're always on notice that you're going to be removed at some point. And sort of success, if you like, is getting to the end of your career and choosing when to retire. So the happiest departing CEOs are the retiring CEOs who are truly beloved, and it's sort of like a tour of duty as they walk out the door, leaving sort of big shoes to fill for the new CEO. But do I see people walking out the door? I don't know. I think it takes a certain sort of person to be a CEO. You have to be pretty self-contained. So I think there's a preference for people who don't like the pressure to go into private equity and just run a business. Whereas if you don't mind the limelight and the pressure that comes with it, I think they're still okay. So I think maybe it's horses for courses, but there is a type of CEO who would prefer to go to private equity and just go under the radar, do the job, make the company what it can be. And then there's the type of CEO who quite enjoys...
like politicians.
Yes.
Totally.
Yes.
The prima donna CEO, and there's a lot of them. Very successful, but they're clients of ours and we love them as well. but I just want to go back on my contention that I put before about boards and the changing composition of boards. And I made a pejorative reference to the old fuddy-duddy male, chair, and of course they're not all like that, and many of chairs are very progressive, understand the importance of values and culture, and are able to deal both empathetically and firmly with the executive team when required. But my personal experience is that the considerable volume of female directors has led to this tipping point, I suppose, where you'd say, do you know what the data is, Lucy? I thought it's getting close to about 30%, but maybe it's not that high.
Currently, globally, it's 23.3%.
Yeah.
So it could be closer to 30 in
I reckon
Australia.
it is. And it just has changed the dynamic so much more, and a much higher accountability, or a different form of accountability. Is that just me, being sensitive to it, or you're seeing that more than I am, Priscilla?
I think you're right. I also think that you call them fuddy-duddies. I think the phrase I've heard is, what is it? Male, pale and stale.
Well, I take offence at that.
I think the male directors are also changing. So first it was that there were more women on boards, and I think 30% is right. There's a club called the 30% Club, and they've actually had quite a lot of traction in getting up to 30% on ASX 100 companies. But I also think that the type of men that are going onto boards now are more aligned with what has traditionally been called the female view. So absolutely, I agree with you that people are not putting up with misconduct, not putting up with poor behaviour. And I think even the work health and safety law changes around psychosocial safety, it's you don't have to be beaten up to be bullied. And now if you don't feel safe in the workplace, it's not how the person who said it meant it, it's how the person who heard it received it. We're seeing even non-executive directors get moved on because they're too rude, aggressive. And that's a really difficult one, because the role of a director is to challenge, and yet when is the challenge too much?
Yes.
But anyway, that's a different topic for another day. But yes, I do agree with you, Tony, that there's definitely a shift. People are not just walking past bad behaviour.
There's a societal shift.
I think that's right. There's a society has evolved, and then the laws have followed. So the respect to work, the psychosocial safety, you have the activist investors enforcing these standards, employees. So I think it's a culmination of all of that. And I think that there's, what previously may have been issues of culture dealt with by the executive or left to the executive are being increasingly seen as governance issues and relevant for the board in certain cases. So the board are sort of expected to have oversight over culture in the workplace, and if you have a misbehaving CEO, it's in front of their attention.
I'll give you a really specific example. The financial services accountability regime requires accountable people to be accountable, and that includes non-executive directors. When that was first introduced, it was called BEAR because it was only applicable to banks. It was the Banking Executive Accountability Regime. And I was asked to give a talk to a board about what was the UK experience. And the UK experience was that the regulators were looking at the personal conduct of the executives as well as their financial services on the job conduct. And I spoke to the board and said, it's not just are they stealing money out of the accounts, it's also are they harassing their staff. And I was told very politely by a male director, no, this is financial services, it's not anything to do with personal conduct. I don't think anyone would agree with that anymore. We have seen one institution appoint someone and then rapidly remove them because of the outcry, because of their past conduct, known past conduct, and their promotion was considered untenable by the public. And I do think now personal conduct is a reason to be held accountable, not just what you've done financially.
Yeah, that's. I completely agree with that, Priscilla. I was in London in 2019, and we worked regularly with the financial services team, because in the event that, you know, someone who worked at an accountable person at a financial services firm had a conduct issue, it became a heightened importance, because if you get a strike on your record, it makes it difficult for them to move around the industry. And it was a huge focus on non-financial misconduct.
Well, on that cheery note, thanks so much, Lucy. Priscilla, thank you so much for joining us on today's Inside Employment. And I'd like to say to everyone who is watching or listening to this podcast, we really do value your feedback. We would appreciate any comments that you might have about what we're doing. Of course, any suggestions for other topics to do in our podcast, please contact any of us. We're all available on the Herbert Smith Freehills Kramer website, or you can send your direct feedback to insideemployment@hsfkramer.com. Thanks for joining us, and we'll catch up again soon.